Hi, Brian Roten, senior reporter for Hotel News Now. I am here with Dana Kravetz, managing partner at Michelman Robinson, and we're here to talk about a case that's being heard by the Supreme Court dealing with complaints against hoteliers through the Americans with Disabilities Act. This has been an area of law that's been long affecting hotel owners, particularly with physical accessibility for properties. We've seen in recent years that spread into the digital realm with website accessibility, things like that. But right now, the case before the Supreme Court, Dana, if you could just kind of give us a little bit of an idea of what are the basics of this case, how did it get to the Supreme Court, and then we can go from there.
Yeah, of course. Thanks, Brian. I appreciate you having me on. I think it's a sort of a threshold matter, and if you sort of go back in history, so the ADA to begin with has only been around for 30 plus years, 33 years to be exact. So it's still relatively new in terms of a law, and you can see that there's a lot of influence that the law has relative to the hotel space. And if you hearken back before we get into the actual case, if you hearken back, a decade or so, there was discussion about ADA relative to the accommodations physically on site. There were issues. There was a long battle associated with plaintiffs' lawyers who using Google Earth to come down on hotels to see if their pools had the requisite lifts for disabled people to get into the pool. So this is taking it into the digital realm and websites, and whether or not those websites are providing the accurate information relative to the hotel and how it accommodates those with disabilities, I think is something that's getting a lot of attention now, but it's been going on for a couple of decades now, certainly in the industry. With respect to this case in particular, being up at the Supreme Court, there was a split at the circuit in terms of how this is viewed. These testers, we're dealing with people who have historically not been at the properties, no intention of staying at the properties, and whether they would ultimately have standing to bring actions under the ADA. And this, is not something that you would only see in the hotel space. We used to see this a lot with auto dealerships, restaurants, where people would be, not necessarily, this is about more of, wheelchair access, right? People coming physically to a property and whether they can get up a ramp, whether they can get through a showroom at a auto dealership, whether they can get into a restaurant bathroom, in a wheelchair. And so this accessibility has been an issue that is not only hotel centric, but because of the fact that you have so many people coming through a hotel, you can appreciate why the hotel industry in particular is looked at more frequently than others. And so, the idea that someone who's not been at the hotel, or someone who has no intention of staying at the hotel, or no intention of booking through the hotel, could actually have standing is an interesting issue that the Supreme Court, in theory, could tackle. Now, the reality of the case is that there's a couple different ways that the Supreme Court could go. And I'm not sure it's going to give anyone the satisfaction that they necessarily wanted when they first saw the case having been filed. And I certainly can go into that if that would be helpful. I think that, one, you've got a plaintiff where she has said that she doesn't want to bring the case. And so there's an out for the Supreme Court to say that the case is moot. There's no reason for us to even have it. And I think Clarence Thomas, in hearing the arguments, had made the point of saying, if she doesn't want to bring the case, why are we even deciding this issue? And if it really went that way, then this is going to be a lot of hoopla for nothing because they're not even going to address it.
I gotta imagine that there aren't too many cases that go forward where the plaintiff
backs out.
Yeah.
No, I mean, you could see that, usually if the plaintiff backs out, that ends the case. And because plaintiffs and the plaintiffs bar are motivated by money, a lot of times if they don't see money as the end of the rainbow, then maybe they wouldn't want to pursue it. But this train has left the station, and there's a a belief that the Supreme Court probably will not take the out of saying that it's moot, irrespective of her desire to have, pursued the case or not. In which case, you'll get to go to the next step, which is for the Supreme Court to decide the issue of standing. And you can appreciate on both sides how that's viewed from a ADA disability advocacy standpoint, from a plaintiff's bar standpoint, from the plaintiffs themselves. Their look at it is that there's an injustice, that when there is a website that is not speaking to their protected class, irrespective of them staying at the hotel, they should have standing. They've suffered in that regard, just from a humiliation standpoint, if you will, that just that's the stigma associated with them not being able to freely enjoy the website and get the information as anyone else would. And so whether I want to stay there or not, I have standing to bring this action. You get the flip side. You get the hotels who say, okay, I understand the issue. We do our best to comply. If you feel like you've been wronged or harmed in some fashion, as a prerequisite, shouldn't it be that you actually want to stay at our hotel and intended to? Because if you didn't, I'm not sure why I'm listening. Now, if I have a guest who actually wants to book with us and wants to stay and is doing the inquiry and finds that we've somehow not been compliant or compliant enough with respect to the ADA, then the hotel industry, I think, would recognize that there's standing there. But that's where this sort of comes down for the Supreme Court. They've got to make a decision whether they want to address standing in that regard. And there is a belief that the Supreme Court, as it's currently constructed, is going to find that there is no standing and there's no actual harm because there was no intent to actually stay at the hotel, in which case it kind of fizzles, right? The case doesn't have the impact that it potentially could have, but it does beg the most obvious question, which is, okay, if the person had intended to stay there, whether or not they actually booked through, they're not really a tester, but would they have standing at that point? And I think arguably the answer would be yes, they would have standing to bring that claim. Now, you can kind of appreciate how the concern would be that if you had no intent of actually staying at the hotel, of what that would do in terms of a potential floodgate of litigation of claims where the criticism of the claims brought under this statute is that it's just a money grab. There's no real intent of solving the problem that gave rise to the complaint to begin with. There's no remedy or remedial action that the hotel needs to take or is being even asked to take, but, pay me some money and I'll go away. And, having handled those cases, there is an element to that, right? I do represent hotels, and there's been it feels at times like a bit of a shakedown with the person having never been to the hotel, with arguably the violation being relatively insignificant, with our willingness to do a immediate remedial measure, and irrespective of that, it's like, no, pay me money, as if that was going to solve the problem. And so there, with a bit of cynicism associated with that, these statutes do give rise to, at times, baseless claims. At the same time, these statutes exist because it keeps the hotel and puts their feet to the fire to comply. And so, there's a balancing act there in terms of whether you would be okay with someone who's not actually stayed there calling you out. In theory, one of the responses from the plaintiff's bar is, okay, but the solve is pretty easy. Fix the website. It isn't even an expensive one. Go fix it. In which case, whether they stayed there or not, I'm getting what I want, which is a recognition that it's required, a fix, and I'll move on. So I can see both sides of it, irrespective of who I represent. Typically, I do see both sides of the equation. Now, I'm in California, and just to not take it too far afield outside of ADA, but we deal with something here under the Private Attorney General's Act called PAGA, which is a statute under the labor code that effectively deputizes plaintiffs' lawyers to go out there and bring actions against employers for, wage violations and penalize them for it. And we've seen here in California that that's sparked a ton of baseless claims, because the statute is designed to give attorney's fees to the lawyer to find those claims on behalf of the state, allegedly, where the money would be split with the state on a 75-25% basis. But what it's really done is driven a lot of baseless claims against employers, and we've seen a ton of it in the hotel space. from a wage and hour perspective. So, you know, to take that and what we've seen with respect to how PAGA is at times abused, and don't get me wrong, there are plenty of legitimate cases out there. I'm not suggesting there aren't, and there's remedies for that, and there's penalties associated with it. But for those claims that we've seen where they're relatively baseless, the statute has been used and abused in a way to garner quick settlements that feel like shakedowns. And I can see why there'd be a concern for a hotel, which is if the person had no intent of staying here, why am I being shaken down for money? If you wanted to stay here and we did it wrong, we get it, we'll own up to it. But if you didn't intend to stay here, why should we be subjected to it? And I think you could find pretty easily a Supreme Court, again, the way it's currently constructed, getting to that conclusion, which is there's no standing. And then it leaves the issue to still be sort of to be continued. And a lot of times the cases go to the Supreme Court where they will focus on a more nuanced issue relative to something like mootness or standing, and it never gets the full picture of what was really potentially at stake. And so it's a wait and see to a certain extent, but sure. I imagine that case will that decision will come down probably next year, and we'll see how it rolls.
So if the Supreme Court decides that, you know, we're not going to consider this case moot because of the plaintiff deciding I don't want to do this, if they do decide that because the intent wasn't there, there is no standing, if intent becomes the crucial thing here, how do you then prove intent to stay at a hotel? Because what's to say a plaintiff bringing a similar suit says, no, I fully intended to stay here. My bags are packed. I have, you know, I was looking up plane tickets. You can check my search history. What threshold is there then to prove intent to stay at a hotel?
Yeah, I mean, intent is always a particularly factual, intensive look, right? To figure out what someone intended. As a plaintiff's lawyer, I think the burden to show intent is probably fairly low. If I'm simply if I am thinking about traveling, thinking about it, I'd like to go to Washington, D.C. I'd always wanted to go to the nation's capital. And so I start just looking through websites and looking through different hotel options, not really understanding the lay of the land of, you know, 3-star, 4-star, what have you. I just don't know. Well, then if I stumble upon a website which I had never even heard of the brand, maybe I don't know, it's boutique, I don't even know, and they're not compliant, then maybe I didn't intend to stay at your hotel, but I've seen enough on their website that would make me move on from your hotel. Then have I suffered the harm and I got standing? I think a plaintiff's attorney could make the case that they're standing there, irrespective of staying there, not necessarily having the actual wrong upon them, not going through a booking process and finding that they stumbled through, just simply on plainly looking at the site saying, well, I'm moving on from that hotel. I don't feel like it caters to me. And, you know, I don't want to take the conversation too far afield, but certainly with respect to race, those claims and standing has been legitimized. And if you are going to find that there is a hotel that does not cater to your race and there's prejudice there and it's discriminatory, that's enough. So you question why in the disability context it's not enough also, because, you know, it's a protected class as race would be too. And I think that, look, the way the world works, things take time. And I will say, again, from the first comment I made, ADA, 33 years old. There's progress. There's progress there. There's definitely proprietors that are taking ownership of what they need to do within their hotel to accommodate. I think that there's, you know, much more attention to accessibility within rooms, within the layout of a hotel generally. I'm sure people want it to be quicker. Isn't always, but I do believe that you've seen progress and attention. So there's hope there that it's getting closer to where it should be. But I would say, generally speaking, in terms of the disabled in our country, there's more attention on this class than ever, which is good for our country to recognize it. You see it in sports, you see it in Paralympics, you see in a lot of emphasis now on being sensitive to what the makeup of our society is, and hotels play a big part in getting with that program, and I think we've come a long way. But clearly someone who is looking at your hotel and finds that you're not subscribing to that, I can see there being standing just by virtue of I would have considered staying there. I certainly was planning to travel, but I'm not going there, and that might be enough.
Okay. To an earlier point you made about, it's a matter of having to change, adding some kind of description of a physical aspect of the property or, a room type. Is there any kind of, what are the odds you think of the Supreme Court having some ruling saying like, yes, as a tester for this, we rule that you have standing. However, for cases such as this, the remedy isn't monetary. It's the hotel is compelled to make the change to be in compliance.
Yeah, I mean, I understand the point you're making, and you start to harken back to high school government class, right? And you start to look at the branches of government and who's supposed to do what. And there's oftentimes where you would hope that commonsensically that could be the place the Supreme Court would go. And then the response is, that's congressional, that's legislative, that's the ADA. You want to amend the ADA, go back to the other branch of government and go do that. In the same respect, if I'm the Supreme Court, and I think they're not going to do this, but they simply could. I read the ADA. I don't see the word tester in there, and therefore I don't even know what we're talking about. So until the law changes that brings something to us that actually references testers, we're not even addressing the issue, and it's a total punt. I don't think it's going to happen that way. But to your question about, can remedies through the judicial system come about, I think you're going to see instead the pushback would be maybe they tease that out as something to consider, but then that rolls back into the legislative branch to consider the ADA Act and whether it's not, fulsome enough and should be recognizing what remedies look like. And that's why sometimes you'll see, even in ADA related, on the state level, at times you'll see, not ADA, but disability statutes on the books that talk about before you could even bring a lawsuit, you have to send a letter out to the property. You have to ask them to make this remedial change. They then have to say no before you can even start to go to the place of bring a lawsuit and seeking monetary relief. You have to put them on notice and give them an opportunity to cure the deficiency. That becomes something that you find codified, and if it's statutory, then it's legislative, right? So I'm with you in terms of trying to reform some of the law to get it to be more practical, but you'll probably see it come out of another branch.
Right. And I mean, to that point, then, I mean, when you look at the ADA, these cases being brought by the plaintiffs, that's because they're the ones who are out looking for these non-compliance issues, however major or minor they are. And so that's left up to civil action by individuals or organizations that are specifically looking for this kind of thing. That's not something that,
Yeah, I know.
There's not.
I know
So like it's left up to private individuals to do this.
Well, and in the context of race and sex discrimination, the Department of Justice has stepped up in the past and has taken upon that entity to bring the actions. You have not seen the Department of Justice do that in disability. And in the absence of that, which would be much more large scale and obviously getting a lot more, headline grabbing attention there, then yeah, there is a heavy reliance on the plaintiff's bar to serve a role of keeping companies and employers honest about compliance. And so, again, as much as I'm an advocate and as much as I represent the employer on a management side, I can appreciate that the plaintiff's bar and the plaintiffs who file those lawsuits are providing the necessary impact to affect change, which should be required to be compliant with the law. So in the absence of the government doing it, and I'm telling you, I have not seen the Department of Justice take on disability, then yeah, you're going to rely on those plaintiffs' lawyers and the plaintiffs themselves to bring the cases. It's just that tension associated with the legitimate case against the, it's just a shakedown for a quick buck with no real intent of even solving the problem, which is moving on. And there's a criticism among plaintiffs lawyers that they're serial plaintiffs. I think even in this plaintiff in the Supreme Court case, she filed over 600 cases. So clearly a tester, right? No intent of being there. Like, this is not about someone just living in our society who feels wronged. It's someone who's seeking out wrongs and trying to affect change. Someone could look at that and say, and that's right, we need that. We need that kind of advocacy because, the individual who is truly humiliated, who found that the hotel did not comply, may just slink off and not do anything about it. They're not going to file a lawsuit. They're not litigious. They're not in it for that. It's just, I guess this is my lot in life. Well, you could look at the plaintiffs' bar and those plaintiffs who are bringing the action and say thank you, because it keeps the companies honest as to what they need to do to comply. It's the abuse of it that gets called into question often.
I mean, that's always the case, isn't it? You've got there are countless honest ones who maybe they bring, like you said, they bring a suit, or maybe they don't. But then you have, just as with any category of lawsuit, someone who is looking for the monetary gain. I mean, it may bring about positive change regardless, but so it's.
I think so. And look, in the way the sort of life works, when you have that abuse, it still causes an employer, a hotel with new construction, new website design, to think and pause and say, hey, we have an opportunity to get it right. So it is in the back of their mind that as baseless as the claims may be, and if it may feel like a shakedown, the plaintiffs sort of unapologetically, so what it did is raise your consciousness. And to the extent you're going to build again or redesign your website or do new construction, maybe you'll think twice about how you address the accommodations and the accessibility issues. And I get that. I mean, I understand that that's a way to garner compliance, and simply hoping that someone does the right thing isn't enough. And so it's a little check coming from the plaintiff's bar that might further the greater good. I can see that.
Well, we're coming up on our time here, but before we go, is there anything else regarding this case specifically, or ADA compliance issues with hotels, that are related here that you wanted to share that we didn't cover?
I just caution everyone when it relates to the Supreme Court. You rarely get a result where you think that solved all the issues. So it often raises more than it answers, raises more questions than it answers, and that's okay. But I do believe in the prior point I made. I do think that raising the level of consciousness as it relates to this particular class of people is important, and to the extent hotels have it on their radar and have an opportunity to do it right and get it right, they will. And so I think everyone's rowing in the same direction. This case will not end all issues, but it's certainly, I think, even sparking the conversation from the sake of disabled people and their rights is a good thing.
Dana, once again, thank you very much for joining us today. I think this will be really useful for a lot of our listeners.
Brian, thanks so much. Take care. Thank you.
Hi, I'm Isaac Colazo, Vice President of Analytics at STR. Hi, and I'm Jan Freitag, National Director for Hospitality Analytics for the CoStar Group. Tune in to our new show, Tell Me More, a hospitality data podcast.
It's a podcast on the global hotel industry, its current trends, what we're thinking about, and where the industry's going.
And we like to have fun with the data too. Find us on hotelnewsnow.com or wherever you listen to podcasts. Subscribe today.
This interview was conducted on October 10th, recorded and edited by Brian Roten.